Okay, welcome back. I'm Susan Hankin. I'm going to be moderating this panel on current litigation approaches to factory farming. We have two panelists, and between them, they've taken lots of approaches to fighting factory farming, and in fact, together they've taken lots of approaches. And they've worked on so many cases together, they're going to have a joint presentation and tell you a number of ways, a number of different federal and state laws they've used to fight factory farming. So let me introduce both of our panelists, our two panelists. So sitting further away from me is Jessica Culpepper. She's food safety and health attorney at Public Justice. It's a nonprofit public interest law firm that pursues high-impact lawsuits to combat social, environmental, and economic injustice. Before joining Public Justice, Jessica was a staff attorney at the Humane Society of the United States in the Farm Animal Welfare Division. Jessica has worked on a number of areas to reform systems that use animals as commodities. Her work is now focused on holding industrial animal agriculture corporations responsible for their abuses through cutting-edge litigation. While Jessica's primary practice is in environmental litigation against CAFOs, concentrated animal feeding operations, her Public Justice's food project is also involved with litigation challenging ag-gag, unfair labeling, check-off funds, and abusive business practices by vertically integrated animal agriculture companies. Sitting next to Jessica is Eli Holmes, who just flew in overnight from Oregon. She is an attorney at Blue River Law, a private public interest litigation firm in Eugene, Oregon. Eli has represented the Center for Food Safety in the landmark Cow Palace RCRA, that's Resource Conservation and Recovery Act lawsuit, against 4 dairies for groundwater contamination. She co-counsels with Public Justice, and she's currently working on a RCRA case in California for groundwater contamination. She also represents Arkansas Rights Coalition and ALDF in fighting hundreds of potential poultry operations in Northeast Arkansas. She was on the Cricket Hollow Zoo trial team, ensuring the first ruling that endangered species in captivity are subject to ESA's taking provision. Previously, Eli managed the Center for Food Safety's Animal Factories Civil Litigation and Administrative Docket, addressing issues ranging from potentially harmful animal feed additives to enforcement actions against animal factories. So without further ado, let's hear from Eli and Jessica.
Anything about us, we thought it was important to show you our sweet animals. And on the one with the kitty, and that's my dog Zuba in the bike trailer there, those are my 2 beloved pets. And they fight to see who gets rides in the bike trailer, and we have a nice little pet harness. Yep.
And mine are the 2 60-pounders on the other side of the slide. Ella is 10, she's a rescue from Alabama, and Fig is 2, and he's a rescue from Eastern Oregon area. I call them the princess and the caveman.
So we thought it was important before kind of getting into all the different litigation approaches to let you know where we come from. And I had the food project at Public Justice, and I'll probably call them PJ, and that's what I mean, Public Justice. PJ represents those impacted by industrial animal agriculture. So that means animals, the environment, farmers, communities, consumers, workers, and nonprofits. And our focus is really challenging harmful corporate practices. And that differs from a lot of other advocacy groups who maybe challenge the government or do, primarily administrative work. Our focus is really going against corporate practices. Our goal, the stated goal of the food project, is to promote a more sustainable, honest, humane, and safe food system by attacking systemic inequities that have allowed a corporate takeover of our food system focused on extracting profits over sustaining communities. And so we view impacts kind of in almost concentric circles, right? First you have the health and safety of farmed animals, and then you have the health and safety of the workers in CAFOs and slaughterhouses and processing plants. You have the health and safety of the communities that live nearby, health and safety of the ecosystems and the environment surrounding the factories and further downstream. You have harm to smaller farms using humane and sustainable practices, and of course the health and safety of and transparency for consumers purchasing and consuming animals or alternative to animal products. So that is just a little background on how public justice approaches our litigation.
So Blue River Law is a different model. It's not a nonprofit corporation or association like a lot of groups that work on the factory farm problem. Blue River Law is a private public interest law firm. I started it in 2013, and I represent nonprofits, I represent underrepresented communities and individuals with the goal of providing them legal services to assist them primarily in the factory farm fight. I do other kinds of pollution-related and public health-related and animal rights-related work as well, but the main focus of my practice is on the factory farm problem. And for the way that I think about what my firm offers is I help groups that are trying to figure out how to fight a factory farm, come up with a legal strategy, how to get them information to enable them to fight the fight, and I have the skills to be able to litigate both in federal court and administrative procedures if that becomes necessary. One of the things that we're finding is that there's a lot to learn about this area of law, and it's constantly changing. So sometimes during the course of litigation, we learn certain things that can help us build the fight even further. So that's why I have the sort of circular design of how I think the strategy of my firm works, is because it's a continual process for myself and for my clients.
So one other piece of background that we thought was really good to give you is kind of how we're approaching the problem with industrial animal agriculture, and letting you know kind of what our definition is, so that you can see, I think that'll help you understand our litigation approaches going forward. So, you know, I think industrial animal agriculture is what? It's CAFOs, and that's right, concentrated animal feeding operations, which are, just for anybody who doesn't know, kind of landless facilities where concentrations of animals are farmed, and waste, feed, and mortality is all gathered into one place, as opposed to spread out over either multiple companies or, you know, like pasture raised and based on the land. You have anything to add to that?
Just that there's, EPA has regulations that define what constitutes a CAFO or a factory farm. And so we use that a lot of times as thresholds. And if any of you are familiar with the regulations and also with some of the case law, you'll note that the threshold for what constitutes a large CAFO is very different than what we're actually seeing in the world when we see CAFOs that have 12,000, 50,000, 80,000 dairy cattle.
Yeah, either way, we're talking about big, big facilities, right? And it's important because, depending on the case, it's important because there are certain legal avenues that you can only take against CAFOs as defined by EPA regulations. And we'll get into that. There are other laws where that doesn't matter. You know, I think industrial animal agriculture also includes the transportation of animals to and from breeding, growing, finishing, slaughter operations, transportation of feed, transportation of manure, slaughterhouses, processing plants, and the fact that most of these things are vertically integrated, which means that since like 1820, right, these corporate practices have become, rather than different companies, one company buys up the feed, the processing plant, the slaughterhouse, the access to markets. And so in order for any other facility or farm to access any of those things, the processing plant, the slaughterhouse, the grocery stores, you have to work through the corporation.
And I'd say that it used to not be every aspect of the factory farming industry in the United States that we saw that, but we are starting to see it in more of the other areas. Like it used to traditionally be hogs and chickens, and we're starting to see some consolidation in the dairy industry as well. So this is becoming a bigger issue for us to deal with.
Yeah, so for example, hens grown for chicken meat, 99.9% of them are run by vertically integrated companies like Tyson. 95% of pigs grown for pork, 99% of turkeys, 78% of cows grown for beef, and 97% of hens confined to make eggs. All of these are owned by vertically integrated companies. You want to talk a little bit about the problem?
Yeah.
Yeah.
So, you know, we only have about an hour, so we're going to address things in a somewhat cursory way. So if you're not already familiar with what are some of the highlights of the problem of the factory farm model, these are the general categories. I mean, the basic problem is that they are an inhumane way to raise animals and to treat animals, and the model is environmentally and economically unsustainable. The inhumane conditions, I think a lot of folks in this crowd might already be familiar with some of the practices that are undertaken at these facilities to control animal behavior, to change the breeding cycle, to change the way that the animals are fed, and to basically manipulate them into being food-producing machines.
Yeah, you know, at Public Justice, the focus is what happens when you view animals as commodities purely for profit extraction, right? And so the problem comes in the concentration of animals, right, which creates the need for debeaking and tail docking and all kinds of other horrific conditions for them to live in, the concentration of waste, the concentration of the market control, and concentration of the narrative over what food means and what Americans should be consuming. And so you'll see as we kind of go through the litigation that a lot of our different approaches are addressing exactly those problems. Mm-hmm. And so the other, you know, what I just mentioned was that one of the problems is the narrative, right? You know, my friend Bruce says something that I always love, which is, whenever do 90% of Americans agree on anything, right? Ever. But what they do agree on is better living conditions for animals. They agree that our animals should be treated well if you are going to farm them for animal products. And, you know, a recent report, a 2015 report by Consumer Reports, say that they want good living conditions, right? So you just have an enormous number of consumers saying, we want our world to look like this. And the fact that industrial animal agriculture is controlling the narrative, is controlling the market, is controlling what consumers see and changing how they view it, is a necessary problem to fix if we're going to change the system. So what can be done? And we're going to talk a little bit about our different legal approaches. And so I think, you know, the primary thing that we're going to talk a little bit about today is our Resource Conservation and Recovery Act case, and that's mostly because it's a landmark case, and I think can go to a lot of these concentration problems that we were just talking about. But there are a huge number of tools that can be used, some more effective than others. Yeah.
And I'll just say on that is that, you know, going back to one of the first things that Jessica was mentioning, like the kinds of problems that exist here, like we've got worker issues and animal issues and public health issues and environmental issues, and we're trying to find ways that we can identify whatever the facts are for a particular situation, what is the Achilles heel of that particular situation, and what's the law that best suits to work on that. So just because we focus on a case and we argue heavily on an environmental issue or on a public health issue, it doesn't mean that we're not concerned about the animal rights aspect or we're not concerned about worker safety. We're just using the facts that we have at a particular scenario to make the best argument we can to change the law, to change the practices, and to shut this model down.
That's a good point. So why don't we talk, first about using environmental laws as a tool. I like what Eli just said about how you have to use kind of the best tool available. And, the pros to using environmental laws is that it forces an industry to internalize their costs. And so that impacts our profit margin, right? It makes this model less sustainable from a profit standpoint. It also helps impacted communities directly. So the people living on the fence line, the animals and the ecosystem surrounding the particular factory farm, it is an immediate relief to them. And in terms of the narrative, it helps us build facts, kind of going back to Eli's information, informing strategy, informing litigation. Getting discovery and getting the facts in these cases will help us show consumers and the American public that, these aren't like bucolic farms with the animals out on pasture. They're more like coal-fired power plants for animals. You want to talk about this too?
Yeah. Well, I was just thinking about the Center for Food Safety the other day put a picture on their website that is basically a demonstration of the size of the industrialization of animal ag and also crop agriculture. And if you have a chance, you could take a look at that, because the opening shot is of lines and lines and lines of veal houses, basically, and it's a very disturbing image. All of them are, but I found that one most difficult. And it's just, these are not family farms. They might be owned by families, but the fact that we have an image in our mind as to what is the bucolic red barn in Wisconsin and what you actually see here in a lot of these cases, and the amount of waste that they're producing and how the practices are run, it's highly mechanized and highly controlled. It's just not the concept that I think most people think of when they have the idea of a family farm in mind.
Yeah, well, and it's worth just going back really quick. So that is a mega dairy. And, the veal crates are in the lower right corner. And the mega dairies that we're going to talk about had, hundreds at least. Veal crates just lined up in hot sun, and, food and water, she said mechanized, is delivered by a truck. So these animals have no access to any comfort from another being whatsoever. It's horrific to see. So 2 cases we're working on, right?
Yeah.
The first one is one that we won in 2015, and the second one is we're waiting any day now. Any day now to hear from the judge on our summary judgment ruling, and both of the facts of the case are really similar.
I'll say just one piece of background on both of these cases. They both focus on groundwater contamination from dairies. And when we brought each of these lawsuits, not only was there a lot of due diligence that the attorneys and the clients had to do to prepare the case, but the reason why the clients and the attorneys were in a position to bring these cases in the first place is that in both situations for 10 plus years, 15 years, citizens and community groups in the area had been working very, very diligently to call attention to the problem. So I'd just like you to keep in mind when we talk about these cases that it's not like we just saw a fact pattern and were able to move forward. There was a lot of work and a lot of community work and a lot of advocacy on the ground that had to occur for a long time for these to be in a good position to move forward with litigation. And I just say that because there's so many aspects to fighting the factory farm model that we'd love for you guys to keep in mind to see where you can plug in.
Well, and I think that these two cases are really helpful, right? Because they show, I mean, it's a good illustration of how we did that strategy, where the first case was against a cluster of 5 dairies, and the EPA themselves had said, okay, look, these dairies are the problem. They are, what did they say, most likely? They, you know, and that's good for EPA. They say it is most likely the cause of the groundwater. And you're talking like schools, right? Public schools, a community of 300 households at least. And these are 5 just enormous dairies kind of all next to each other, back to back to back. And so that was Eastern District of Washington. So within the Ninth Circuit, right? And then we move on to Blackwood, the Blackwood case, which is in the Central District of California, but also within the Ninth Circuit. And so you'll see as we kind of talk about these facts that it was a very, I think, conscious decision to do different district court, same circuit, so that the ruling, the very, very good ruling in the Cal Palace case would have some kind of precedential effect if it were to be viewed
Followed,
by the judge. If it were followed, yeah. So do you want to talk maybe just about like the contamination and how we got to the case at all?
Yeah, so the contamination that we're talking about here is groundwater, and this is both, to the extent I can, I'll try and generalize about both the cases because there are similar patterns here. It's groundwater, so most of the rural community got their drinking water from the groundwater. They have individual wells on their homes. And the main contaminant that we were looking at here is nitrate. And nitrate is when manure decomposes, nitrate can be found resulting in the remaining manure. And if it gets into groundwater, it can contaminate the groundwater, it can travel with the groundwater flow pattern, and so if you have a dairy that is putting nitrate into the ground, it can end up in neighborhood wells. It can cause certain health problems in humans. Blue baby syndrome or methemoglobinemia is the primary one. I worked really hard to say that. Blue baby syndrome, which basically depletes the baby's ability to process oxygen. And it's a very dangerous condition, especially for children under the age of 5. But it can affect anyone. It can affect adults. There's lots of thyroid problems, and the World Health Organization, the Institute, IARC, Institute A for Research on Cancer, recently declared that nitrate is, I think the language is, again, most likely a human carcinogen. And so we've been finding this in wells down gradient from the dairies, and we know that with the quantity of manure that's being produced by these dairies, there's likely a connection between high levels of a contaminant and the dairies. And so our work has been focusing on how to, legally speaking, make that causal connection. And with some of the cases in the Eastern District of Washington area, we've been working a lot on Clean Water Act cases. And with the supplemental environmental projects that came out of those cases, we were able to start to build the studies that needed to be done to help us make that causal connection. And in both cases, we had EPA in the Yakima area and the State Water Board in California start to get interested to do their own studies and to do their own testing. And that's really something that is pretty remarkable, even though you would think that's their responsibility. It's remarkable that in both of these cases, the state and federal agencies, for them, kind of took the bull by the horns and was able to help us identify facts that was things that we could use to help protect the community.
Well, and so here's the problem, right, is that they took the bull by the horns and then they failed at settlement, right?
Yep.
And so in both cases, there was a voluntary settlement with the clustered areas in Washington, it was with the EPA. In California, it was with the State Water Board. And, you know, with the EPA, it was under the Safe Drinking Water Act. And with the State Water Board, it was under basically the California state version of that, right? The Porter Cologne Water Act. And so the problem, right, is that they start out firm and then the industry comes in and it waters down. And so you start out with a settlement and, you know, through discovery you see drafts of these settlements. And they start out with good language. And then by the end of it, it's all voluntary. And so at the point that we came into both of these cases is when we looked at this settlement and we were like, this is never going to work. This is never going to change the practices at the dairy. This is never going to fix the problem in the community. And so all of these studies and all of this science is really important because the tool we chose to use was RCRA, the Resource Conservation and Recovery Act. And the importance in that is that the standard is really lenient, but there is an exemption for agricultural waste, and including animal waste produced on CAFOs, if it is returned to the soil as fertilizer, right? And so the major question here is when you have 12,000 dairy cows and you dump, you know, hundreds of thousands of gallons of liquid waste, and the cows are like living up to their bellies in it. When you're scraping all that out, when you're flushing all that out into lagoons, spraying it on fields, like, is that fertilizer? And of course they say yes. What they refer to it as what?
It's a byproduct, a beneficial use byproduct.
Liquid gold.
Liquid gold.
Liquid gold.
Yeah.
That's what they call it. And so
the famous quote is, I think one of the Washington area dairymen is, you know, when he goes past a CAFO and there's the strong, pungent smell of manure, I think the famous saying is, smells like money.
right. Right, which goes back to what we're saying about animals being viewed as commodities solely for profit extraction, right? So what we have to do is we've got this great tool, and for law students in the room, I think it's worth breaking down a little bit. The reason it's great, the reason you want to use RCRA instead of something like the Clean Water Act is that it's very protective of public and environmental health, right? And whereas the Clean Water Act, maybe you have to get a permit, maybe you have to stop a discharge, under RCRA, you have to actually like clean it up, right? And you have to stop, so you have to stop the discharge, but you also have to clean it up or make provisions to make it as if the impact weren't there. And that is such a broader remedy. And so the actual language, I think, is worth reading. It's any person who has contributed or who is contributing to the past or present, and then it's like this long list: handling, storage, treatment, transportation, or disposal of solid or hazardous waste, and here's the key, which may present an imminent and substantial endangerment to health of the environment. So you have any person who's contributed, and then you have which may present. And so there are some tricky legal issues, but that is a really, really protective standard if you can convince a court that all of this manure from all of this concentration is a waste and not liquid gold, right?
Yeah, and we don't have to wait for the pollution to happen. We don't have to wait to show that a discharge happened and a discharge violated a permit. We can say, look, these conditions are such that they may present the harm. It's a much more forward-looking and more protective statute.
So I think when you're looking at everything that was similar here, you know, we waited for the facts to bring this argument. And I think that we won, right, because of waiting for those facts and developing it. But what happened in the Eastern District of Washington is that the court completely agreed. I mean, it was a 108-page opinion?
111.
111, if you feel like some fun evening reading tonight.
Pages 100 to 111 are the best, in my opinion.
But, you know, it's just full of this amazing case law where he says, right, you know, anything that you put on the soil that a crop can't use, that's waste, right? Like, you are in RCRA territory after that. And so we can take that tool, and the point is, when you're doing this kind of litigation, is to take that and then build off it. And that's where the Blackwood case comes in. It's like kind of the next one, because it has that same fact pattern. It has the state even stronger, right? The state saying, not only is it most likely, they're like, no, you actually are the cause, and you need to stop, right? And so we had even stronger facts in this case. It's a smaller, it's only one dairy and it's only one community as opposed to, schools and all this other stuff. But it's a really good model to take your fact pattern on to the next court. Mm-hmm. Yeah. I have no idea which slide is next anymore. Right. So, I think that the practical effects of this are, because this is the animal law conference, so I hope you're thinking, how is this going to benefit animals, right? I mean, this is getting communities clean drinking water, and that's really important. But what the court ruled was that, and you'll have to help me out because it's a lot of stuff, but they had to scrape the corrals more frequently. They have to lay down bedding more frequently. So right there, when you're seeing cows living up to their bellies in their own filth, that is wildly helping them. But also, they're not allowed to put as much manure on their fields, which inherently gets back to the concentration issue, right? If you can't put as much manure on your fields and your watershed is already saturated, you have got to break down some of that concentration.
Mm-hmm. And you've got to, if you can't find a way to get rid of it compliant with the consent decree, then you might have to limit the number of cows that you have on your facility. And I'll just note, to build off of one of the points that Jessica made about the scraping of the corrals, I think in the Cow Palace consent decree, they have to scrape, I think it's monthly. And that's a big deal because there's a lot of manure. And I think typically before that, it might have been language along the lines of once a year or
Right.
on an as-needed basis. So,
Right, so there were certain facilities who were doing it once every 3 years. Right.
yeah, so it creates a lot of problems. Like, there's a lot of health issues that the cows suffer from standing in their own manure, if it's the dry season or if it's the wet season. And so there's a lot of illnesses that can affect the animals. And when you have this many animals confined in this area, you can imagine that, certain diseases or infections can spread quite quickly, and so they affect the animals that way as well. I will say, just on the nitrate piece, one thing I've seen reference to it, but I don't have any super strong scientific basis for this yet, is there is some thinking that nitrate in drinking water is also related to, we know it's related to reproductive problems in humans. But I've seen some suggestion that nitrates in drinking water might actually cause spontaneous abortion and reproductive problems in cattle as well. So, we talk about it mostly, in this case, from the RCRA angle, because that's what the standard says is for health or the environment. But
Public health of the environment.
public
right.
health, the environment. And so, there's other implications for the animals' welfare as well that come about by having this ruling.
Right, and obviously things like fish kills from downstream impacts,
Mm-hmm.
all of those things. And so just to go back to law student crowd, I think the other really important thing here is to get technical is the agriculture exemption, which is in the regulations, it's not in the law itself, allows us to more clearly define manure as a solid waste and not as a beneficial byproduct, right? So if you're looking at RCRA, if you're reading about these cases, or if you're wanting to do these cases in the future or now, a lot of the case law discusses, right, when does something become a waste? Because you have all of this kind of terrible case law where, telephone companies put a chemical in a pole and it leached out and oops, but it wasn't intended as a waste. So the fact that we are very carefully helping courts to view, and hopefully thereby the public to view, this as a necessary industry with a byproduct that is incredibly deadly, I think the better.
Okay, we're going to switch gears. One of the other environmental laws that we've been looking at using recently is the National Environmental Policy Act, or NEPA, and the Endangered Species Act, the ESA. And this is an issue that ALDF has been looking at for a while, and I know that I've been looking at, and we were able to work together on contacting or reaching out and communicating with the Arkansas Rights Coalition which is a small group in Arkansas. And I'll just say from a practice perspective, one of the things that I think is really important is to have cases or issues that are brought forward by a local community group and national organizations, because it's really important to show that these are issues that are not just, the NIMBY approach, and that these are things that have real, true, hardcore merit that federal agencies or private defendants need to consider more seriously. So what we have going on right now is in Arkansas, the Arkansas Rights Coalition has a new poultry operation that is proposed to go in very close to some members of the Arkansas Rights Coalition. And in the course of looking at that, we realized that there's a significant amount of federal money that the poultry operation has applied to receive, $1.3 million, a portion of which will go to a personal residence for the CAFO owners. And we realized in looking at that this one particular facility was not the only one. In fact, there's approximately 1,000 broiler houses that are forecasted to enter the northeastern Arkansas area. And so ALDF and Arkansas Rights Coalition have been working really hard to gather the information for the community to learn about what's going on, because it's happening very quietly. And that when you're, if each of these facilities is getting $1.3 million, assuming they're all applying for federal funding, which is just the sort of hypothetical that I'm using, we're talking about a $325 million federal project. And as a result, there has to be environmental assessments done under NEPA, and we've obtained documents through FOIA to look at the environmental assessments that are being done, and they're very substandard, in my opinion.
They're bad.
Yeah,
They're sad.
They're 13 pages. They're highly repetitive of each other.
Right.
There is no meaningful assessment. I don't know if any of you are familiar with the requirements of NEPA, but it does require that the agency take a hard look, or the case law requires that the agency take a hard look at the environmental consequences that are likely to result, and you have to look at direct impacts, indirect impacts, cumulative effects. And none of that is being done for any of the individual facilities, and certainly not on an entire region-wide scale. So,
well, that's what's really interesting, right? That's what's really interesting about this particular case, is that it's saying, okay, government, it's not even enough for you to look at the cumulative impacts from this broiler facility. You need to look at the cumulative impacts of these 1,000 broiler facilities all coming in. And this goes directly to the concentration issue, right? Because, was it a slaughterhouse that they were?
yeah, so 2 slaughterhouses came in. There's nothing. There were very, very few CAFOs in this area. It's a beautiful canoeing area, great watersheds, a lot of endangered species, including the hellbender, which is, I'll show you a picture. Oops, that's not one. How do I, there. I'll show you a picture of the hellbender. This is the hellbender, and there's also the Missouri bladderpod, which is a very protected flower, and mussels. It's a low-lying area with lots of water-based aquatic species, and none of them are being considered.
Right, so you have 2 slaughterhouses coming in. So you have goes back to vertical integration, right? You have 2 slaughterhouses coming in, and they say what they say. All right, we're going to build this, and this is going to boost your economy, but if we're going to do this, we need X number of broiler, which is hens raised for meat. We need X number of facilities to come up to support our slaughterhouse, which is going to help your economy and watershed, I'm sure. So I think in thinking about this and thinking about the importance of this, thinking that if that is how they approach it, right, if they can go and they can open up slaughterhouses and then suddenly the industry feels obligated to support those slaughterhouses, that is exactly the kind of control that we're trying to break down.
Yep. And I will say just, some of the things that were looking at in that case is there's also, one thing that you need to be aware of when you're looking at these cases is regulations change and guidances come out. And so just in the last few months since we've been looking at this, the final greenhouse gas guidance has come out from the White House, from the CEQ. And so that's something that we're seriously considering and using here, because when you go from having zero slaughterhouses to, zero broiler houses to 1,000 plus the slaughterhouses, there's going to be some greenhouse gas changes. There's also been new regulations that the Farm Service Agency issued in early August, which make their NEPA review requirements more stringent. So definitely, as you're looking at these things, keep on top of what's going on with the agency, because frankly, they're getting in a tougher and tougher position to justify their lack of review under NEPA and their failure to adequately identify the endangered species in the area. And I will say that one thing that we've noticed, particularly in this case through the FOIA documents, is that it's the banks that are doing the identification of the species in the area, and the banks that are making the recommendations to the federal agencies how to treat these projects. So I don't know about your banker, but mine doesn't know what a hellbender is.
Well, and, talking about cumulative impacts and looking at the CEQ report, animal agriculture is the largest anthropogenic emitter of ammonia in this country. It's responsible for 80% of the ammonia. And the highest concentration of ammonia comes from hens, right? From hen manure. Mm-hmm. And so all of these things are really critical to kind of keep in mind. So moving away from the environment, another way that we're fighting this is by fighting transparency, right? Dealing with transparency. So, I think tomorrow there's a panel on the First Amendment, and you're going to hear probably a lot more about things like ag-gag and that approach. But I think it's important in terms of litigation strategy that you're looking at your entire toolbox. So the Constitution and consumer protection laws and all of those things are really critical additions. And so, for example, we're currently representing a coalition, including ALDF, and DC-based consumers in an attack on Hormel's marketing and advertising of their Natural Choice brand. And you can see the slide up there. It says, "Bite for your rights." And so just kind of the insinuation of what that means, right? You are choosing as a consumer to choose a better product, and what do you think that product means? And, this case brings in not only consumer protection laws, it's coming in under a DC-based consumer protection law called the DC Consumer Protection and Procedures Act. It's a very broad act that prohibits generally deceptive and unconscionable practices, right? But it's also dealing with the Constitution, because one of the major arguments is whether or not coming down with sort of a state judgment on the marketing campaign. Usually it's labels, but this is an interesting case because this is actually focused on the marketing of the labels. But whether or not doing that on a state level is going to preempt, so you have the Supremacy Clause of the Constitution, if it's going to preempt federal rules, right? And the Supremacy Clause says that basically federal rules, the law of the United States is what stands. And so, it's really important as you're looking at fact patterns to think about what is the impact of this, and is this going to impact federal laws if I'm looking at a state law? If I'm looking at a federal law and I have a state law against me, can I use the Supremacy Clause for me to fight for animals? So I also want to talk a little bit about opening markets, right? So I think some of the transparency stuff that we'll talk about is discussing how to open up the narratives, but a part of that is just dealing simply with markets, right? We are, ironically, representing the largest independent group of cattle ranchers. And we're doing it against beef checkoff funds. And I'm not sure if people here are familiar with beef checkoff, so I'll spend a sentence or two just telling you. But basically, if you raise cows for beef in this country, for every head of cattle that you sell, you pay $1 into the state beef council, right? And let me see, their mandate is to promote beef consumption. And so if you think about $1 per head of cattle from everybody, everywhere in this country, and imports too, all being paid to a council that promotes beef consumption, that's a really terrifying thought when you think about concentration and control of the narrative. And so how do you get at that, right? And one way that we're getting at that is that in Montana, which is where these cattle ranchers are, in Montana, they pay $1, and 50 cents of that dollar goes to their local, right, their local council. So you have one that's like, what is it, beef, it's what's for dinner, right? Hang on. Yeah, beef, it's what's for dinner. So you have that one. But then you have another one that's supposed to kind of, as a more local level, represent you. And so in this case, there is absolutely no policing over how this money is getting spent. And so the money that they were paying to represent their interests went to fund Wendy's advertising. And Wendy's advertising does not buy their cows from Montana. In fact, they don't even buy their products from the US. And so and as you can imagine, these small, independent, so not part of a vertically integrated company, these ranchers are really upset. And so we are arguing, we're using the Constitution to say it's compelled speech, right? This is a First Amendment argument, and it's compelled speech because the government is taking their money and forcing them to basically advertise for imported cows from Brazil. And, they're not okay with that. And so this is a way, right, going after these checkoff funds is a way that we can sort of try and break up the control over the narrative. And again, I think it's best to leave a lot of the discussion of ag to tomorrow for the First Amendment because those folks are going to be way better at talking about that than I am. But I think it's also worth just saying that something you should keep in mind is the Equal Protection Clause, right? So if you're looking at laws and how they are impacting advocates or people trying to break down the concentration of this industry, are they targeted, right? Are they targeted? And so under the First Amendment, you can't target a specific viewpoint. But another part of that is the equal protection. Basically, the argument is that that group is not getting equal protection under the law. They are not getting equal protection of the First Amendment. And so that's, not only are you getting a free speech argument, which is a very, very powerful point and one that courts pay a lot of attention to, but you also need to bring in the equal protection as much as possible. And so Public Justice is lead counsel representing a coalition of groups, including ALDF and a lot of people in North Carolina. And one thing that you're seeing is that the laws are being expanded. So in North Carolina, I think one of the scary things is that the Chamber of Commerce is really who drafted this law. And so it not only impacts advocates, journalists, whistleblowers in general dealing with factory farming, it outlaws whistleblowers in like a nursing home, a daycare facility, all kinds of places that you want transparency. And so this is going to be a really interesting case to move forward. I'll leave that to tomorrow for a really in-depth legal discussion on the First Amendment issues in that case, but I do want you to watch it as it moves forward because this is a good example of how these are being expanded, right? And so the last thing I want to talk about is opening the markets and the Packers and Stockyards Act and other antitrust laws. What you see there is a cute little game, not called Monopoly, but called Monopsony. In Morris v. Tyson, we are representing, again, interesting, right? Interesting bedfellows, but you go at this where you can. We're representing farmers who became contract growers for Tyson. And after they contracted with Tyson, they believed that they were treated unfairly and forced into a problematic system. So one thing that Tyson does, well, two things that Tyson does is the first is that they make you take out hundreds of thousands of dollars, if not millions of dollars in loans. And so these people are immediately indebted, right? And the way that it goes is talking back about the banks, right? Is they get the loan from the bank, and Tyson sends the check directly to the bank, right? And then they get the rest. So it's a worrisome system. But what the growers here are arguing is that when they signed the contract, they lost complete control of how they could run their facilities. So that meant that they had to pack in more birds, and they had to use less humane practices, and that if they didn't follow those, and if they didn't take out the loans and change their equipment to make it more concentrated and more profit-driven, then Tyson's punished them. And so they did things like withholding medical care for their hens, or sending them bad feed, or sending them dead chicks. I mean, just horrific, you know, like literally dumping truckloads of dead chicks on their doorstep as a punishment for balking the system. And so we are trying to say that Tyson is playing favorites, right? They're taking over an entire system, and they're kind of carving it up by region, like Pilgrim's over here, Tyson's over here. And if you live in an area, you can't contract anywhere else. And so you can't operate a business unless you do it their way. And that is a monopsony, right? That is anti-competitive. And so we're trying to use market-driven laws to address that. Last thing.
Okay, I'll be quick on this. It's a tool that probably many of you know, and if you don't, then
On the basis of almost all of our lawsuits.
yeah, you can find out. The Freedom of Information Act, there's the National Freedom of Information Act, the federal law, but then every state also has their own open records law or Freedom of Information Act. Sometimes counties or towns also have their own, and you should be using this tool regularly to get information. A lot of the factory farms that we address are regulated by the state or by the federal government. And so they have to do things like provide annual reports and their nutrient management plans, and there's all kinds of information that they're required to report that relate to, mostly to environmental factors. They're typically regulated by a state Department of Natural Resources or Environmental Quality, but also in California, I think it's called the Food, Drug, and Agriculture, or Food and Agriculture Division, where you can find out certain other pieces of information about how these entities are regulated. So we've submitted a couple of FOIA requests just asking for basic information, where we've been told that we would shut down an entire agency because we wanted information about one CAFO. So this is, when you get reactions like that, you know that you're hitting a sore spot.
Well, and you want to talk about ag-gag, right? There are laws being passed all over the place. There's one that just got passed in Ohio that exempts the State Department of Agriculture from having to turn things over, right? So you can't get that stuff in Ohio now. And we were like rushing to get in our FOIA request before the deadline hit, and they're like, oh, we didn't see it in our email. And so there's yet another type of transparency where they're hitting us hard, is in FOIA. It's something to pay attention to.
Yep. And just to highlight one of the ways that we're using it, in Wisconsin, I had clients that were asking information about a couple of CAFOs, and they were basically blacklisted by the state agency. So we had to take action to demonstrate to the state agency why blacklisting someone for asking for information that they're entitled to was not proper under the law. And again, this is the kind of thing where sometimes it doesn't result in a lawsuit, but we need to be able to keep the pressure on the agencies so that folks can preserve their rights to access this information about factory farming. Jessica was mentioning international influences on the production system here in the United States. We've actually been using FOIA in a couple of situations where we know international producers are coming in and buying old slaughterhouses and converting them into more modern ones and re-expanding the factory farm network in certain areas. And we've been using FOIA to try and find out other sore spots that particular factory farm international producer might have. And so we've been working with some agencies that aren't used to getting FOIA'd.
Well, and people are stupid, right? Like, they don't pay it. I mean, really, you know, I mean, I don't know if you've been seeing on social media, but all that stuff about the United Egg Producers and Just Mayo, right? Like, that was FOIA. Like, those guys put that in an email and it got turned over. Like, what were they thinking? But that is all over the place. People don't think. And so you can get a lot of really powerful things using Freedom of Information Act.
Yep. Okay. So, this is for the Star Trek
I
and
did that.
science fiction fans in the
I-
audience.
I did that. You know, really, I think it's a good time to turn it over to questions. But, you know, the idea is that we are continuously, and I hope that you are all continuously, taking information and thinking about new cutting-edge ways to use it, and also keeping your ears open to the sore spots and trying to put things together. You know, these were just a couple of examples. Our dockets are really vast, and in fact, if you want to learn more about what we're doing that we don't have time to talk about, you can go up to the information table. There's a flyer, and it has a lot more detail about each one of these cases that we've been talking about.
And one thing I will just say too is, you know, we cover a vast amount of territory in what we're looking at. And I think it's fair to say that there's no shortage of cases out there.
Right.
It's just a matter of putting them together. And it takes a lot of work, and it takes a lot of FOIA, and it takes a lot of diligence on your part as attorneys or clinics or supporting organizations that do this kind of work and the advocacy. It takes a lot of work. And so if you're interested in this, you know, there's plenty of opportunities to help push the ball forward. So we'll open it up for questions then. Thanks, Susan.
Hi, I'm Michelle Inman. I'm with the Oklahoma City University School of Law. I'm a 2L, and I'm on the law review, and I'm writing my law review note on a proposition that Oklahoma is putting up to vote on State Question 777 about amending their constitution to protect all practices of ranching and farming so that no law can be passed without a compelling state interest against a rancher or a farmer, which really protects factory farms. Again, this is one of their ways of protecting themselves against, you know, not only the ag-gag stuff, but protecting from environmental issues, cruelty issues, all kinds of things. So I'm writing my note about that. And my question to you is, I had not realized that there were some cases pending on exactly these factory farm issues on the dairy industry and all that, so that's really great. I want to reference these cases in my note. But in your perspective, from your experience with handling these types of issues, if in fact there's two other states that have passed similar amendments to their constitutions protecting ranching and farming, it's Iowa and North Dakota, I'm sorry, Iowa and North Dakota. Now Oklahoma is considering it, pushing it to the voters. In your experience, would you, given the fact that there's constitutional issues, there's the federal government statutes, there's things like EPA and that kind of stuff, would you think that that kind of amendment to the Constitution really would prohibit, I mean, could they really get away with anything they wanted to? Couldn't we use constitutional issues still to try and bring suits against their practices and procedures? I mean, they're talking about future procedures. They're locking the local state legislatures are locking them from doing anything to enact any kind of laws to regulate them, both from environmental standards and welfare standards. But could we still use the Constitution or federal government, as you said, the Supremacy Clause, to try and override some of that? In your opinion, what would your take be on that?
I mean, the first thing you do is look at the language of it, right? I mean, my sense would be yes, I would certainly bring up a Supremacy Clause argument in a situation like that, but I would need to look at the exact language of it. And the fact that it exists in 2 states, I think, means nothing, right? Ag-gag exists in like more, a lot of states, more than a dozen. And so the answer is to find the weakest one and then test your legal challenges. And I'm not sure if it's that one. And of course, litigation is like one leg of the stool. And certainly if there's pending legislation, I really hope that folks who are active in legislation are really fighting that. But, if I were approaching that case, what I would do is take all of them and look at the language and find the most egregious one and then compare it to the law in that circuit, right? And find the best kind of the softest spot with the best precedent versus the weakest law and test it, right?
Okay, that sounds good.
You got anything to add?
No, go forth.
All right, thank you.
Hi, my name is Nora Constance Marino. I'm an attorney in private practice in New York. I have a couple questions about your cases, Care versus Cow Palace and Blackwood. I do a lot of personal injury, and I was wondering if you hired experts for that. I'm assuming you did, to determine the toxicity of the soil, and who paid for them, because my experience with experts is they are a fortune. And did you have any evidence of anyone actually getting sick from consuming this water, where you could have had some type of a personal injury claim against the CAFOs and sued them directly and omitted the government agencies with whom it sounded like you had to rely on for your lawsuit?
You want to talk about the experts, I'll talk about the money?
Yeah.
Yeah, okay.
So experts, yes, we did hire experts.
Hydrogeologists.
Yeah.
Yeah.
Yeah, so I'm just thinking where to start. Yeah, so we had hydrogeologists and soil scientists
Right, yeah.
primarily, and public health experts in the Cow Palace case. And, the reason is we want to, when we put cases together, we want to make sure that they're successful.
I know why we need experts. I mean, I use experts in my cases. I'm just, like, who is your client? Because you mentioned that you had the...
I'm sorry, is this your question? I see you're reading from your phone, or is this a question?
These are my
that you're-
notes.
Okay.
These are just notes I took during your talk. You stated that the government drafted the settlement, so like who, or that it got watered down. I was just unclear of what was
So
happening
the
there.
clients were Center for Food Safety, and the local community had become a nonprofit advocacy. So the clients were 2 nonprofits. One had members in the area with impacted water, but also national organization. The other is completely local, based within, 5 miles
yeah.
of the dairies.
And so was your theory of liability that this water could get someone sick, or it actually did get
No,
someone?
could, right? So RCRA only says may, and so you don't need to show.
You didn't
only
need an
to show
actual
endangerment.
injured party as a plaintiff.
Yeah, all they need to do is have exposure. And so their wells were above the maximum contaminant level, the MCL for nitrate, which is 10 milligrams per liter. And so, some of them were like in the 60s and 70s. And so that is our argument, right, is that is enough to show an endangerment.
And then the RCRA statute that you relied on, you said something that the settlement got watered down. It started out strong and then got watered down. Who watered?
Yeah, so it started out, EPA used the emergency powers under the Safe Drinking Water Act. And under the Safe Drinking Water Act, there's only certain relief that the agency was allowed to seek. And also under the emergency powers, there was only certain relief that the agency was allowed to seek. So first of all, the agency could have gone under RCRA, but they chose not to. So from the get-go, they were approaching it not as aggressively as it could have been, or in our opinion, as it should have been.
Right.
And as we did.
Yeah.
Right,
And so
sounds
that
like-
was the first problem with it. The second is, a lot of time, trying to remember some of the specifics about the EPA agreement here, but a lot of times, if you need well monitoring, the wells might not be placed in the correct spot to detect the pollution, or they might not be placed at the correct depth, or the monitoring might not be frequent enough. So there's a lot of those specifics that, when you have an expert like a hydrogeologist or a soil scientist look at it, and they're like, they're missing the pollution, they're missing the whole point of what this agreement even can do under the Safe Drinking Water Act.
Well, it sounds like some very serious litigation, and kudos to both of you. It's a great case.
Yeah, thanks.
Good morning. My name is Ashley Cartwright. I'm president of Generation Veggie, a nonprofit dedicated to help raise vegan and vegetarian children. My question is have either of you been involved with or can speak of the National School Lunch Program and how ag and dairy is so involved in what the standards are.
Yeah, I've been wanting to deal with that for a long time.
Me too.
Yeah, I mean, I have vegan children, right? And so this is really, and they're in school. And so this is personally really important to me. But also I think, man, it is, like, I think it's a really ripe issue, I do. I think what I would love to see is some kind of fraud. And, but I think it would be a really interesting case to deal with it from the way that they're advertising it and the way that parents are relying, like what they believe versus what is actually being consumed by the children. Yeah, I don't have anything off the top of my head, but it is something that a lot of us are really interested in. I think there's a lot of different ways to go about it, right? So one is from a marketing standpoint, and that's a really interesting way. Another is from a fraud standpoint, and I think that that has been done a little bit with the beef recall, right? But I do agree that if the right facts presented themselves, and unfortunately this is not a place where FOIA is that helpful, but if the right facts presented themselves, I think it could be an incredibly powerful case. The issue with the school lunch program is one of, I think, intense investigation where you don't rely on FOIA, you look more at like where the money's going, follow the corporate trails, and so you need a lot of investigation into SEC filings and looking at who's getting the grants and tracking it back to sourcing. But certainly, I think if the effort were put in, it would be a fantastic case.
Okay, great, thank you.
Hi, I'm Randall Boots. I'm a 1L at Vermont Law School. And you talked about using the Endangered Species Act to combat CAFOs. And I was wondering, what is your success rate there, and how much does that help? And what exactly, what are kind of the tactics that you use in order to use the ESA? So in terms of like, do you need to hire scientists? Do you use the data that's out there already? And then actually structuring your argument, is the ESA a large part of that? And how is that part of the argument structured?
Yeah, so that is kind of in the early stages. So there's only so much that I can use now to answer your question. So I think the Buffalo River case, which was also a NEPA case, I believe that they also had an ESA claim. And that was in a wild and scenic area. So I think there was a different kind of habitat there to have some protected critters. And so, but the main focus in that case was on the NEPA angle. And what we're doing right now is using the ESA. Primarily, we're using what I'll call it's the Section 7 consultation provisions. And what we're noting, and what we've noted in the public comments to the agency, and what we've noted in significant new information letters that we've sent the agency, and in a ESA notice of intent to sue, is that the action agencies under the NEPA process did not appropriately identify the species under the Section 7 consultation. So we're kind of using the NEPA ESA angle together. And we're also saying that they did not use the best available science as they're required to do under the law. So currently, the notice of intent to sue letter focuses on those two aspects of it. And we'll just have to see where that goes and if other information helps us push other angles of the ESA. But I think it's a tool that would be great to use. Again, it's very factually specific, based primarily on habitat considerations and feeding and foraging and breeding and all of those behaviors of the natural animals.
Okay, great, thank you
Stay
so much.
tuned.
Thanks.
So it looks like we have time for one more question.
Thank you. I'm Paul Locke. I'm from Johns Hopkins. Thanks for the great presentation. I just had one quick question for you on the issue of factory farming. You, I think, spoke a lot about factory farming on land, but my understanding is factory farming has now been undertaken in an aquatic environment. And I just wanted to ask you if you knew anything about that in the United States, where it's happening and how it's happening, and not to make your job more complicated, but is that something you might take on in the future?
I'll just say that I'm coming back later today because Kathy Hessler's talking about that, and I'm really excited. And it is on my radar, so I think that is, it'll get a lot more into that there. But
Yeah, and it's, I mean, basically the aquaculture is CAFOs in the water.
Yeah.
They're administered feed additives, they're administered antibiotics, and other kinds of things to keep the fish or shrimp or clams or mussels healthy. So I think there's a lot of similarities and parallels in the problems. I believe there is a petition pending, and it might be the Center for Food Safety that did that, on addressing some of the issues there. But I haven't seen any pollution-related lawsuits yet.
Not yet. I think it is on everybody's mind, though, and we're aware as it's becoming more pervasive that it's a problem that should be stopped, particularly if we can get to it before the industry is really drafting regulations that protect them, that now is a great time for that. But, I am not incredibly well informed, but it is certainly something that I want to be and want to look at.
Thank
And
you.
in terms of where it's happening, I know that I've actually seen it in Washington State, in some of the sounds. You can kayak around and see them. I don't think we have any of magnitude in Oregon, and I'm not quite sure what California's rules are. And those are the areas that I think of predominantly, at least on the West Coast, for areas where it's happening. But I think it's also happening in inland lakes, and I know that there's some places that set up essentially a farm
Yeah.
on the land with their own
I've heard of
tanks and
that.
all of that. It's very mechanized.
Okay, well, I think that means that we're out of time, so please join me in thanking our panel.
Thank you all.
Thank you.